5 seconds to go. Start. She submitted that the best interest of the child is the primary principle, which also means the welfare of each member of the family of the child. She submitted that the matter in patriarchy becomes also a matter of gender rights, which is a constitutional issue covered under Article 14, read with Article 15(3) of the Constitution of India. She submitted that the constitutional provisions recognize that women from a separate category who need to be enabled by the law. She submitted that the citizenship of a child has nothing to do with the welfare principle. A child may be a citizen of any country, but if the competent court finds that it is in the best interest of the child that he is brought up in India, the child should be permitted to stay in India. The learned counsel invited our attention to a decision of this court in the case of Kanika Goyal versus the State of Delhi through Station House Officer and another, as well as a decision in the case of Pratik Gupta versus Silpi Gupta and others. She submitted that in these two cases, though the child was a foreign citizen, it was found to be in the best interest that the child remains in India to continue with the prime caregiver. Her submission is that in this case, the child can continue to be an American citizen and stay in India on the basis of an OCI card. She submitted that eventually the child can make his own choice at the age of 18. The learned counsel submitted that the decisions in the cases of Nitya Supra and Kanika Supra are binding precedents, as the same are rendered by the benches consisting of three honorable judges. She submitted that the High Court has completely ignored the binding precedents. She submitted that the learned judge of the High Court cannot decide the case based on his subjective personal opinion. She submitted that it is necessary that clear and consistent law be followed even in the custody matters, and judicial discretion is not used to subvert the evolving law. The learned counsel submitted that in this case a writ of habeas corpus was not maintainable, as the custody of the appellant number 1 is not illegal. She pointed out that in the cases of Nitya Supra and Kanika Supra, directions were issued to the family court to complete the hearing of custody matters within a time frame. The learned counsel submitted that in the cases of Yashita Supra, an exception was made to the rule laid down in the cases of Nitya Supra and Kanika Supra, as in these two cases the mothers had submitted to the jurisdiction of the court in USA. She reiterated that in the name of welfare and interest of the child, the welfare of one of the parents cannot be eliminated altogether. The learned counsel submitted that the appellant number 1 cannot be compelled to go back to USA. Her submission is that if the child is placed in the custody of the respondent number 1 on the ground that the appellant number 1 is not interested in going to USA, the child will be reduced to a chattel. The learned counsel submitted that to refuse a woman the right of mothering is refusing to acknowledge and respect a very core biological and social identity. She submitted that a custody dispute cannot be decided purely in the facts of each case. She submitted that the law laid down in the case of Nitya Supra has to be followed as recently done by Bombay High Court in the case of Union of India and others in Criminal Writ Petition number 547 of 2021. The learned counsel submitted that the issue of medical evaluation of the child requires a detailed hearing. She submitted that the visa granted to the appellant number 1 is only a tourist visa which would entitle her to visit USA only for specific enlisted reasons. She submitted that the stand of the respondent number 1 of supporting the appellant number 1 for getting the visa is illusory. She pointed out that the respondent number 1, by relying upon alleged legal separation, has contended that he cannot support the application for a grant of a green card to the appellant number 1. The learned counsel also invited our attention to the pleadings in the interlocutory applications filed by the respondent number 1. Stop.